Good afternoon. I'm speaking to you today as a settler from my office in Brampton, which is in the traditional territory of the Anishinaabe, Huron-Wendat, Haudenosaunee, and Ojibwe Chippewa peoples. The land that is home to the Métis and most recently the territory of the Mississaugas of the Credit First Nation, who are direct descendants of the Mississaugas of the Credit. We recognize and deeply appreciate their historic connection to this land. We also recognize the contributions of the Métis, Inuit, and other indigenous people, the contributions they have made, both in shaping and strengthening this community, in particular in our province and our country as a whole. I wish to pay my respects to the many indigenous people who live and work here today. I acknowledge that many of you, if not all, have faced the pain of racism in your very own ancestral homeland. Welcome. My name is Justice Kofi Barnes. I'm the chair of the Association of Justice and Treatment Professionals, and welcome to the last of our series of 5 plenary sessions as part of the 2024 Justice and Treatment Partnership Speaker Series. What is the community to do when individuals with mental health and substance abuse are falling through the cracks, unable to access services? What if the services exist but are not being accessed? Peter Keene is going to talk to us about a program that seeks to resolve this issue, the Guelph Wellness Court. Mr. Keene is Crown Counsel with the Ministry of Attorney General. He is Crown Counsel and he works in the Complex Prosecution Bureau. He's going to share his expertise with you, and the opinions he's going to express today are his own opinions, and they do not reflect the opinions of the Attorney General of Ontario. And as he speaks to you, he's also going to tell you a bit about himself. As per usual, there's a Q&A. We'll ask that you kindly send in your comments and questions to Q&A, and Peter will address them appropriately. At this point, the plan is to address them at the end, but Peter will make adjustments if he feels it's necessary. So with that, Peter Keene, over to you. And Peter, just so that you know, you are still muted at this point.
There we go. All right, there we go. So I've got the presentation on the screen. Justice Barnes, are you and the participants seeing that? I'm hearing anyone?
I can see it.
You can see it. Perfect. Okay, so
yes.
So first of all, look, thanks for coming to this presentation today. It's nice to be doing this because this is something of a success story we had in Guelph that's really made a difference within the community. The reason Justice Barnes is telling you I'll introduce myself is I failed to send him a bio so he could introduce me, so that's my fault. I've been a Crown Attorney for about 22 years now. I was an assistant Crown Attorney in the north of Ontario, where I was a flying Crown Attorney. So I got to fly in between a number of First Nation communities doing prosecutions there, worked in a number of the communities in Northern Ontario like Sioux Lookout, Dryden, Kenora, Red Lake, Fort Frances, all throughout the north. And what struck me most when I was up there was the lack of resources that were available for folks who had both addictions issues and mental health problems. Frequently, people in the communities were struggling to find resources that would work to help to somebody who had significant concerns. In early 2021, I had the chance to move down to Guelph and take on a new role. And there, I was involved in setting up something called the Wellness Court. Now, for some reason, my computer's very slow here. Let's see if we can move that up. Okay, there we go. Okay, so let me tell you about the Wellness Court structure and what it is. It's a relatively new court that we've set up in Guelph, and it started up in November of 2023 after a couple of years' work trying to get it going. And although we call it a wellness court, the vast bulk of the people who come through have mental health and addictions issues. We found that a mental health court could be a stigmatizing term. And so one of the folks who was setting this up said, look, we need a different name because people will be turned off attending a mental health court, but they may well be prepared to attend a wellness court. And so we have a court that runs half a day a week in the Ontario Court of Justice, which is one of those little strip mall type courthouses in Guelph. And there are 4 groups of people that we serve through it, and 4 streams. And I'll be talking about those streams as I deliver this presentation. The first stream is what we call our stabilization stream. And these are for folks who are floridly mentally ill, very, very significantly ill, often can't really work well with the court system or the folks who are sort of trying to assist them. The second group of people who's helped through this court is what we call our drug treatment stream. There is a small drug treatment court that's existed in Guelph for many, many years. It serves a very, very small number of people who have sort of determined that abstinence is a goal they want to try and accomplish in their sort of journey towards health. The third group of people that we serve are what we call our wellness diversion stream. And these would be folks who are typically going to be diverted relatively quickly out of the criminal justice system, but who have some significant mental health issue that they need some assistance with. And the fourth group of people is what we call our wellness stream. And I'll discuss that a little bit later. This court runs about half a day per week in the Ontario Court of Justice. Now, I'm not sure why. Oh, there we go. Okay, so where did this court come from? When I arrived in Guelph, this was sort of during the height of COVID. My job at that point in time, when I got here to Guelph, was to run the office. We had about 10 crowns, about 6 or 7 support staff, and a very strong defence bar in the community, I was pleased to see. But what was happening during the sort of early 2021, mid 2021 period of COVID was a significant disconnect between folks who had mental health disorders and between the court service. Now, for those of you who are old like me, you may recognize, here's Johnny from The Shining. And this is an image of somebody who, it's from a movie a number of years ago, somebody who was having what can only be described as a significant mental health crisis. And he became very angry, very disconnected, very sort of detached from reality in some degree, and he began behaving in a way that was very, very dangerous. And what I saw happening repeatedly, and what we as a community were seeing happening, was as a result of the Zoom-based appearances and the transition from in-person case management to Zoom-based case management in our courts, is we had a number of floridly mentally ill people. They were very sick. They were frequently dangerous. They were frequently obviously needing mental health supports. And they were folks who, in part because of the degree of their illness, were simply unable to work productively with the community mental health services and the folks who might be able to help them. Frequently, they presented very paranoid. Frequently, they presented very angry. And when we were dealing with these folks, you know, I recall several quite vividly. We had one gentleman who was sort of smearing himself in feces each time he came to court. We had another gentleman who was cutting himself each time he came to court. We had another gentleman who was smashing stuff each time he came to court. And all of these people were sort of in a place where they obviously desperately needed help, and the system was struggling to provide that help to them. So what was happening with these people is it was apparent to everybody that these folks needed help. Duty counsel, crowns, judges, the jail. And the jail at the time reported having a number of people like this in their institutions, which made things very, very difficult for them. Everybody was frustrated. So that was the first thing that struck me, is we've got a bunch of people coming through our courts who are very, very sick, and we're kind of struggling to provide services to them because of the way the system's currently set up. Now, ordinarily, if you've got somebody in custody who wants to speak to sort of somebody outside custody, like a lawyer, there's some hoops to jump through to do that. It can be a little bit difficult for somebody outside a jail to get in touch with somebody inside the jail. You know, if you're defense counsel, you have to arrange an access defense call. The accused person has to be able to come to that call. And for these folks who are very, very ill, little things like arranging a phone call or responding to a phone call were just beyond them at that point in their lives. So they obviously need help, and we need to be getting this to them. Now, there was a disconnect here, and the disconnect was that I'd moved from a community where there was really, really limited supports for people to a community where we had fabulous supports. One of the great things about being in Guelph is the strength of the community agencies that are out there, and the strong defense bar that we have here. And what we saw happening here in Guelph was we had a plethora of services available for people. So we have a very strong Canadian Mental Health Association that's and their interactions with the court were still being run by Rory McClellan. We have the Stonehenge Therapeutic Community and Homewood Health Centre, which are both mental health and addictions services treatment organizations where you can go inpatient. We've got obviously Ontario Works, we've got housing associations, we've got the Guelph Police Service, the Provincial Crown, Public Prosecution Service of Canada, Defence Bar, we had shelters, we had social housing. There's all kinds of services within Guelph that were available to assist folks like these very ill people who were coming to court, but nobody could get in touch with them. CMHA reported they couldn't speak to the person when the person was in custody. They really needed to be in court, but they couldn't be transported out of court because courts were by Zoom. So there was this disconnect between folks who really desperately needed help and the strong community services that were available in here in Guelph. Now I'm going to pause for a second before I move on, because I tend to sort of launch myself into these things. Justice Barnes, are there any questions that are coming up on the Q&A that people want me to answer so far?
Nothing yet.
Nothing yet. Okay. So there's the disconnect. And what we identified, and when I say we, there was a series of people, there was a group of people who came together to sort of try and get this wellness court off the ground. And the central problem was that there was no hub, there was no central court time when all the community-based mental health and addictions workers could come to court and deal with the numerous clients they had. What was happening was all of the service agencies were being spread a little bit thin. Like the courts, people were having to work from home. Like the courts, what used to be in-person service centers where folks from the community would drop in to get services, whether it be addiction services or mental health services, those things are all broken down because of the need to social distance and because of COVID. And so all of the networks that people had that allowed folks who need help to get access to services had significantly broken down. And the workers were being run ragged because they were running to different locations and different places to try and provide services. So put yourself in the position of a community mental health worker who's maybe working for CMHA, and let's say you've got 20 clients. Well, those 20 clients might be on 20 different days over a 2 or 3 week period, or a month-long period. And so workers are going from court to court to court and eating up a lot of time trying to provide services. Very inefficient. So as this was being seen, lots of people were seeing the same set of problems. So from my perspective as the Provincial Crown, I was really worried about these folks. I've got a cousin, quite frankly, who I've known since he was very, very young, and he suffered a brain injury at a young age, had to have part of his brain removed. And the result of that brain injury was, unless he's well managed, unless he's well taken care of, he becomes frustrated, angry, and can become violent and aggressive. So you've got to know how to manage the guy. So I had a personal interest in folks like this, like the people we were seeing coming before the court, largely because many of them I thought could probably be helped if they could get access to the proper services. We also had a member of the defense bar, then a lawyer, Matthew Stanley, now Justice Stanley, who was concerned about the same things. We had Rory McClellan from CMHA in Guelph, who was very concerned. And we had a series of people from Legal Aid, the police, Public Prosecution Services of Canada, and the judiciary, all of whom had an interest in trying to sort of try and deal with these problems. So what we did is, this began with myself and Matthew Stanley, and we formed a steering committee. What we did is we reached out, each of us, to the folks that we knew within our spheres of influence, and tried to get them on board to bring what we were calling then a mental health court to Guelph. And people came on board, I think, fairly quickly on this, largely because there was this obvious central problem in the community that needed to be addressed. So we formed a steering committee and ultimately got this court off the ground. Now, the way I'm going to structure this presentation is I'm going to first of all talk about the end result, in other words, what's happening in this court, and I'll then go and talk about sort of the process of getting this thing up and moving, what the barriers were that we ran into, what some of the successes we had, some of the mistakes we made, and things like that. Okay, so first thing we discovered fairly on is we couldn't just do this ourselves. We couldn't just say, hey, let's magically do a court in the community. When we reached out to the local administrative judge, he said, yeah, I can't do this. I can't set up a court in Guelph for you. I can't even set you up a court time to run a court. And that's because statutorily, under the Courts of Justice Act, there's only one person in Ontario who has the authority to do that, and that's the Chief Justice from the Chief Justice's Office of the Ontario Court of Justice. And to get to that person and to get them on board, there's a whole bunch of people you need on board on the way. You've got to have your local judge on board, your local administrative judge on board who administers the local courts. That local administrative judge needs to get the regional senior justice on board, who needs to get the associate chief justice on board, who needs to get the chief justice on board. So there's a process to follow and a whole series of people who are going to be involved in a movement like this. It's not just a case of sort of saying, hey, we think this is a good idea, let's do it. To give you some sense of the challenges that courts have got, it's been commonly talked about the sort of different pressures that a court has to deal with, the different individuals, groups the courts have to address. And we're all familiar with sort of the backlogs, I suspect, that exist in our court system. And so the judges at each of these levels are dealing with all kinds of competing pressures upon them. So if a court like this is going to be set up, as it ultimately was, you've got to convince a fair number of people that this is in the best interest of the community, of society, of the courts, and it's going to work. So let's start talking about the stabilization stream. The whole court, with one exception, is based on consent. And what I mean by that is you can't force somebody to get well, okay? That's not going to come as a surprise to anybody, sort of, I suspect, on this call. But you can't force somebody to take treatment and hope that will be successful, all right? So for all of our streams, except this one, consent is central to it. An accused person is in that court because they've agreed to, after being made aware of what the advantages and disadvantages of the court are, what might be the outcomes. Only with their consent will they be in this court. The stabilization stream is different. And it was this stream that actually prompted the sort of move to create this court. And this stream is for accused persons who are currently in crisis. So these people are very sick. They typically have untreated mental health disorders. Frequently, you've got mental health issues and addictions combined, and so individuals have both sets of problems, not always, but frequently. And typically, these individuals are floridly ill. It becomes apparent within a few minutes of speaking to them or them being in court that something is very off mentally, and we may not know what that is. Most of the time, these folks have ended up in custody. Not always, but most of the time that's where they are when they come to us. Frequently, they're facing offences that are offences of public concern, offences that are putting the public at risk. They're not often in court, in custody for shopliftings. Usually, these folks are resistant to mental health interventions. And the reason I say this is our mental health teams in Guelph are experienced in trying to get people on board to actually take treatment and to make use of the services that are in the community. They're really good at that. But there are some folks who often in part or primarily because of their illness, aren't able to meaningfully work with the mental health teams. And so these folks are often very resistant to mental health interventions. A lot of these folks require hospitalization if they're to get better. And a number of these folks pose significant security risks. So the folks who are coming into the stabilization stream aren't coming in on a consent basis. So the way this would look is I might be in a court, or a defense counsel might be in a court with a client or an accused person who is visibly very, very ill and resistant. Maybe the person's angry, maybe the person's speaking in a way that demonstrates there's some delusional disorder going on. Maybe there's a lot of paranoia they're expressing. Frequently, you may be dealing with somebody who's very upset, very agitated, and it's apparent they need some help. So what would happen with that person is that person would get referred into the wellness court. And the immediate goal of that was to connect that person with community resources. What's unique about the wellness court in Guelph is it's a hub where all of our service providers come to at the same time. All the clients are there. And the idea is that people are there who can do an intake with somebody in real time. In other words, they can come into that court, be told we've got somebody coming in, and they can do a meeting with the person. So a CMHA worker, for example, may go back into the cells, sit down with the accused in the lawyer's interview room, and have an initial conversation with them. So the immediate goal of stabilization was to connect people to community resources, to deal with the problem that the mental health workers just couldn't get in touch, couldn't speak to somebody because the person's in custody. Often, that'll have a good impact. Somebody who may appear to me to be not capable of working with CMHA turned around and said, no, they're actually prepared to work with us now. We've explained what the program is. Okay, great. The second goal, usually with folks coming into the stabilization stream, was to engage the court's assessment tools. One of the great things the court has that outside the court process and outside some of the form processes that exist for hospitals, where an individual can be hospitalized without their consent if a form is done, is we can require somebody to attend and take an assessment about their mental health. Doctors or psychiatrists are working on the basis of a court order, so don't require the accused persons to consent to conduct their assessment. They can get background information, and they can give us details about what's going on with this individual. My experience in the North, where we did this regularly, because it was often the only way we could get services for somebody who needed mental health services. The experience of just meeting with a doctor meant that frequently that person, if they've got some ability to work and interact with a doctor, may end up consenting. So somebody who comes into the system non-consensually after meeting with a psychiatrist may then begin consenting to some form of treatment or medication, which can help stabilize them. So in the North, we saw a lot of people going through the assessment process. No treatment order was done, but through work with the psychiatrist in the institutions, the person would start taking treatment, start receiving medication, and would suddenly get much, much better. Through the assessment process, that may happen, it may not. If it doesn't happen and the psychiatrist comes back and says this person's not fit or is not able to interact with the court system because of the degree of their mental disorder, we may be looking at treatment orders and things like that. And so for some folks, not a huge number, we may end up doing a treatment order on someone. That's the immediate goal. Try and help somebody stabilize from where they currently are. Try and get them to the point where they can speak to counsel, where they can interact with CMHA workers. The medium-term goals was and I say medium-term because this is sort of the goals that would come through 3 weeks, a month, a few days, depending on the individual and what the issues are, would be to get a diagnosis, would be to link that person to psychiatric care, would be to establish legal supports with that person, often through legal aid and by getting them counsel. We'd be linking that person to community mental health, and we may well be linking that person to other services such as housing services, ODSP, or Ontario Works. When the steering committee was working on setting up this this court, the members of the steering committee wasn't just a bunch of lawyers. The last thing you want is a bunch of lawyers sitting around a table trying to sort out problems of the world. We had real people who do real work, who were trying to sort of help people in the community. And what was the folks who worked for the community services agency said, look, we've really got to have ODSP here. We've got to have somebody who can help people with Ontario Works. We've got to help somebody who can help with housing services and things like that. Because frequently what's underlying these folks is significant disenfranchisement from society is a whole series of problems: poverty, addictions, housing, mental health. And I suspect most of the people around in the room today listening to this presentation will be used to dealing with folks who have multiple concurrent problems in multiple areas. And so the whole point of this was to get this person linked up with a number of services that may be able to help them. Now, I don't want to give you a rosy view of the world. We do not suddenly have a magical access to thousands of housing units in Guelph. Nor do we have suddenly a magical ability to get people into housing sort of overnight. But what was happening is the folks we were seeing were so disenfranchised and so sick as they were disconnected from everybody. When you're angry, aggressive, mentally disordered, paranoid, you don't tend to work well with people who are trying to help you. And so a lot of these folks were very, very significantly disconnected from the things that were needed to help get them better. Because I can medicate somebody, or a court can medicate somebody as long as it wants through a court treatment order. But if you don't have housing, if they're going straight back into a community upon release into a location where they've got no services, that temporary improvement in their mental health will be just that, temporary. So the whole point of this was to have people from multiple services who could provide something like a wraparound service. So entering the stabilization stream, this was not consensual, unlike every other stream. The folks that we're dealing with in that state weren't able to consent. And the referrals and a remand to the court could be done by anybody out of any court, most often by the Crown or the Defence, often prompted by a community partner, but anybody could refer somebody to the court. One of the things I'd observed, and we'd observed through observing other specialized courts, is there's often some hoops to jump through to get into a court. And when we set this up, let me back up for a second. The reason hoops exist is quite simple. Everybody in the court, the judge, Crown, Defence, community partners, all have specific jobs to do, all have specific duties, sometimes constitutional duties. So I am constitutionally bound to engage in fair prosecutions. A judge is bound to make sure that, if there's a trial, it's a fair trial, is bound to ensure that if sentencing submissions are made to them and a sentence is requested, that a fair and just sentence is imposed. And so when we'd observed other courts operating, we'd seen that there was often a referral and application process to go through to get into the court. So, somebody had to fill out a form, they had to get to the decision maker had to sign off. And all it took was someone to be sick, someone to be away, someone to have a personal problem, someone to be on vacation, for that entrance process to get disrupted and for it to take a long time to get into the court. And so when we set this up, this was deliberately set up in a way that allowed folks to get into this court quickly. So the stabilization stream could be referred by anybody. Now, that also means that when you're into this court, there are folks who can put a stop to this. So, for example, we have a small number of people who are very angry, Yes, they have mental disorder, but not a major mental illness such as schizophrenia. They may have borderline personality disorder or something like that, which isn't really amenable to treatment. And who are engaged in repeat ongoing criminal behavior, and for whom there's not good information that we're going to be able to assist that person. That might be somebody where either the Crown or the judge or defense may say, this is the wrong place for this individual. So people can be referred out. By and large, the participants within the system within Guelph had a sense as to who should be in this court, and so referrals were made. The person would show up, and we would start trying to assist them. Now, Justice Barnes, are there any questions so far?
No questions.
Okay, thank you. So the next stream was the drug treatment stream. This is a traditional abstinence-based drug treatment model, and this court in Guelph has existed for a long time. It serves a relatively small number of people, individuals who have identified a goal of abstinence. Most of the people who are in this court are facing significant penalties if they don't go through the court successfully. And it works very, very similarly to the way that the drug treatment court in Ontario worked, at least in Toronto worked, at least from my observations. All of the folks who come into this will be connected with community-based supports. A plan of care would be developed by the accused and service providers. This would be approved by either the Crown Attorney or Public Prosecution Service of Canada, but for practical purposes, the person who runs this is Erica Quayle, who is the PPSC lawyer who has been running that court now for many, many years. The program is lengthy, 12 to 18 months in length. Guilty pleas required. And again, like all the other three streams, consent of the accused and all participants is required for that court to be taking place. This court existed for many, many years. And because of the nature of the court, it serves relatively few people. But and what's happened is this is now one piece of our drug treatment court. I believe it runs first thing in the day, and then the rest of our wellness court takes over. Interestingly, it was actually Erica Quayle who came up with the name of this court. She said that, look, when we're dealing with people who have both addictions and mental health, if you called a mental health a court, people immediately get turned off by that because they say they don't have mental health problems. They don't have a mental health issue. There's other things going on. People are doing bad things to them. People are being mean to them. People are committing crimes, and they're the victims. And so frequently, the folks who would be well served by a mental health court didn't want to be there in part because of the name. She suggested the name Wellness Court, and it was something that just resonated with all the people who were involved in setting this thing up. The next stream within the Wellness Court is what we call our Wellness Diversion Stream. Now, if you've worked in any courts in Ontario in the last sort of decade, you're probably familiar with a program called the Direct Accountability Program. And this is a program in which somebody is referred to, usually because they're facing a minor charge, often first-time offenders, but someone's referred to the Direct Accountability Program. They do some community-based sanctions. It might be a course, it might be a donation, it might be making restitution, it might be doing volunteer work. And through their work in the community, they make up for the offense they've committed, and the charges are then withdrawn. The Direct Accountability Program has a target of getting their matters through the system and dealt with within 90 days after a referral is made. The Wellness Diversion Stream is really based on that model. And in fact, many of the service providers who provide services to the folks in that stream come from this model. Sorry, I have a dog underneath me who is guarding me apparently. So please excuse that. This group of folks was experienced working with the type of clients who have both mental health and addictions issues, because a large number of the clients who were going through that program were facing those types of problems. And the twist was that we added a mental health component to this, not as an additional sanction, but as an additional service. So where somebody identified, wait a second, this person could use services from an addiction services organization or from the CMHA, the person would come to Wellness Court because that hub of service providers is there, and we can then make the connections and hopefully provide services to those folks to better assist them through the court system. So, excuse me, the vast bulk of these folks are dealt with fairly quickly. Cases could be longer if in fact that was required by the case, by the charges, and by the sort of treatment team who was dealing with this individual. The next group of folks is what we call our wellness stream, and this was something new. So up until now, everything I've described to you kind of existed in Guelph, but wasn't working as well as it could because of the disconnect between service providers, accused persons, and the fact that people were being run ragged going to different courts. The wellness stream was new. So we get, if you're a Crown attorney, and again, when I'm saying this, Justice Barnes was correct. When I'm speaking, these are my opinions, not the opinions of the Attorney General. We always speak on our own behalf when we speak in these things, in these types of presentations, because we don't get to tell you what the Attorney General thinks unless the Attorney General's told me what he thinks and what that person would like to be conveyed to folks. So the wellness stream, we deal with a number of people who are facing charges where realistically non-jail ain't an option. Okay, normally. So, for example, if you're engaged in a stabbing of somebody, most of the time you're looking at a custodial sentence, maybe a conditional sentence of some kind. But we get plenty of cases coming into the system where somebody with a significant mental health disorder has committed a relatively serious offense. And it's apparent to everybody that that person, if they go through the regular court system, will get a jail sentence. It'll be moderately long, 6 months, a year, 2 years, whatever. And at the end of that jail sentence, the person's back into the community. And we're not going to help the community, we're not going to help that person if all we're doing is locking them up, throwing away the key for a year and a half, and then bringing them back into the community. More needs to be done. And so when we've got somebody like this who has what appears to be a significant mental health disorder, the directives in Ontario tell us we have to take that into consideration, and we should. It's often a mitigating fact for accused persons. And we start looking at what the best way to protect society, prevent a recurrence of the offense, help the offender, help them rehabilitate, protect the victim. How can that best be accomplished in these situations? And jail is not always, sometimes jail's a good answer, but it's not always the answer. And sometimes there are much better answers out there. So where we had somebody like this, and the case has been screened for a significant jail sentence because that's what it's worth if it went through the regular court system, but where we think the risk of a reoffense can be mitigated through this court and through the offender's engagement with the mental health and social services supports, they may go through the wellness stream. This is something that looks much more like the drug treatment court. So a plan would be developed by the coordinator, usually the Canadian Mental Health Association, requiring the person to do a number of things. Maybe it's to attend appointments with a psychiatrist. Maybe it's to to take medication. Maybe it's to appear daily in a drop-in center. Maybe it's to appear 3 times a week and meet the CMHA worker who's dealing with them. Maybe it's to take an assessment. There may be a whole series of things this person has to do. Maybe there's restitution involved. Maybe there's a treatment program involved. It's very specific to the offender and the offense. So a plan is developed by the coordinator. It's run by the Crown and the accused. A guilty plea is required, and the outcome is often a reduced sentence or a non-custodial sentence. So maybe I'm looking at 18 months real jail for somebody. Let's say I've got a stabbing between 2 individuals who are using drugs on the street, one of whom stabs another when both are high. There's a dispute between the 2 of them. Neither really wants a prosecution. The accused obviously doesn't, the victim doesn't really want to be involved. But, if you stab somebody, you would generally go to jail. But maybe this program will work better for that person. And so what would often happen is that this process would actually involve an application form and an application process, because we need to know the accused is committed to actually trying to work on this, able to work with the partners and the service providers. Service providers have to be willing to take the person on, and a plan is developed. And if the accused successfully completes, the outcome is often a reduced sentence. In these cases, the court is often acting as a sentencing court rather than as a case management court or something like that. And so there may well be judicial involvement through judicial pretrials and things like that to try and work with these folks who are coming through the system. So every plan is unique to the offender and the offense, and there can be a whole different set of requirements for that individual. Frequently, the plan is long, certainly longer than a regular diversion program, and the outcome is often quite different. What's interesting when you deal with these cases is the experiences we have dealing with victims. Frequently, our victims either know the accused or have recognized there's a significant mental health problem. And when you've got victims who are engaged in these processes and are aware of what's going on, we often get real buy-in from the victims to what we're trying to accomplish with this particular offender to try and reduce the risk to people in the future. So the wellness stream approach is much more robust, takes a lot more time, a lot more energy. The significant benefit to the accused is a much better outcome in their case for them at the end of the day. And the benefit to society is if an individual's gone through a program like this and has completed the steps they're supposed to be completing, the person's likely to be of less risk in the future. So referrals and entrance. The Crown is a gatekeeper for many of these things. In other words, we can say no to many of the accused, but I don't like to put too much emphasis on that because, frankly, so is everybody else. A judge always has the power to refer people out of this court. And in fact, it's in our founding sort of documentation and in the business case that was approved before the Chief Justice that the judges ultimately have control over the courts because constitutionally they're required to have control over the courts. So the Crown is a gatekeeper for many of these streams, but so is everyone else, with the exception of the stabilization steam. If defense counsel doesn't want the accused to be there, they're not going to end up in this court. If the accused doesn't want to be there, they're not going to be in this court, because everything is based on consent. When an individual, let me give you a bit of a picture. So you've got somebody who's out of custody. They've committed an offense. Let's say it's bad. Let's say it's a robbery. Okay. Robbery, a convenience store robbery. They've now been released on bail. Nobody was hurt. Nobody was stabbed. Somebody threatened a store worker and stole a number of items from a store. So let's pretend that's our offense. Robberies are bad. We don't like those. They tend to be responded to by a real jail sentence by the courts. So the person's at risk of jail. But defense counsel learns this person has had a long history of drug addiction. They were using methamphetamines at the time of the incident. The person has expressed a desire to get off methamphetamines, is in fact working and has employment, but is at risk of losing the employment because of the drug addiction, and just feels awful about what's happened. So let's pretend that's the accused we're dealing with. That might be somebody who's put into the wellness stream or the drug treatment stream, one or both potentially, or usually one. The referral will be made. The person will come to the wellness court, and Crown will be notified. An application form will be filled out for that type of process. And when the accused comes there, they'll meet with a coordinator who, for both the wellness stream and the drug treatment stream, is a CMHA worker. That worker will meet with the person, chat with them, find out about their motivations, find out what they want to accomplish, find out whether or not there's a reasonable chance they'll be successful at the process. Find out what resources they have to assist them in this process, and will then coordinate a plan and coordinate who needs to be involved in this. So if you think about somebody who's using meth, employed precariously, housing may be precarious. That person needs a bunch of different supports to try and prevent things from getting much, much worse. And so that treatment, that the coordinator will set up appointments and meetings with the various folks who will work with this individual. Maybe the person wants to go through the drug treatment stream. Maybe they don't, but they desperately want to go and do a 30-day treatment program somewhere. Once the plan is put together, there are pre-court meetings and coordination meetings that take place amongst the Crown and the various workers that typically take place the day before court, where the Crown and the workers try and work out what's going on with each of those accused persons. Other individuals may well be present for those meetings. Once a plan is put together, the person will be in court. If it's a wellness stream or drug treatment stream, the person will usually plead guilty. Judge will be made aware what the proposed plan is and what the proposed outcome is, and the person will then start their treatment. The importance of this is you've got to have people who can do this work. You can't just come to a court and say, oh yes, Bob needs to do treatment. He should go to a treatment program. Okay, Bob, come back in 30 days and tell us how that's going. You're not going to have success with that type of program. The point of the hub-based model that the courts have developed here is that everybody's present to assist folks with these types of steps. Let's talk about failure for a bit. Wellness courts aren't for everybody. And when I say that, I don't mean they can't. I don't mean that a person, if they're removed from court, can't then do that court at a later date. But there are some folks who are just not capable at the point where they are in their lives of working in a meaningful fashion with a group like the Mental Health Court. We run into a number of situations where people may be referred to a court, but they continue committing substantive offenses. Well, those folks usually end up in jail and incarcerated for a period of time. You may have people who express a desire to work with the court, but are unable to attend appointments. One of the things we recognized when setting up this court was that we're dealing with a population that often has significant difficulties just dealing with the relatively simple steps that you need to be able to engage in to be successful in society. So they may have difficulty attending appointments. People may have difficulty phoning somebody. People may have difficulty with basic hygiene things because they're living on the streets or they're homeless. So we know that the folks that we're dealing with are not going to magically get better when they enter a court or a system like this. And so it's expected that our folks, our clients, will have slips, that our folks will sometimes breach, may sometimes commit another offense. And it's recognized that's a reality of dealing with people who have significant mental health and addictions issues. So people aren't just removed from the program. It's not like there's a hair trigger facing them where if they breach a curfew on an order that they're going to be immediately removed from the program. But people will be removed from the program if they meaningfully lack compliance with the program, which typically means an ongoing repeat failure to attend meetings, for example, with their workers. If there's further substantive criminal behavior, public safety is important. If we can't keep people in a wellness court if they're repeatedly committing substantive criminal offenses, to use the robbery guy as an example that I was talking about earlier, if that person commits another robbery, you can expect the Crown's going to be taking a position they should be held in custody. We cannot tolerate that in society. It's not reasonable to do so. On the other hand, if we've got the robbery guy who breaks down and uses and is arrested for using and is released by the police at the scene, that kind of slip is going to happen with people who are trying to recover from addiction, and it's to be expected. And people would also be removed for behavior that puts the health or safety of other participants, service providers, or court officials at risk. So now and again, when we have these people who are in the stabilization stream, once we've gone through the treatment process, we are often dealing with somebody who's got some mental health problems, but who is very angry, very aggressive, and can't safely be dealt with except through a custodial type system. So if someone's engaging in that behavior, they may well be removed from the program. But as I say, slips are expected. So when we were setting up this court, we ran into a whole series of bumps in the road. And I'm not going to go through the personalities involved. If any of you have been involved in trying to set up a new program, a court, get funding for something, you'll know that you run into bumps and objections all the time when you try and set something up like this. And we did. So I'm not going to tell you who, not going to tell you when, not going to tell you where, largely because we worked through these problems with the folks who were the bumps in the road. The first thing we got fairly regularly, as you do whenever you set up a program, is people telling you they don't have the resources. The way we dealt with that is we pointed out that what was actually going to be happening through this court was making people's jobs easier. Rather than, as a CMHA worker, having to attend 12 different courts to meet with 12 different clients, you could now come to one place at one time. That saved a lot of time. The second barrier we ran into, which I didn't expect, was an objection from some members of the defense bar who said, we just don't trust the court's mental health system. The attitude was that if you went into an assessment-based system, you were going to be locked up, you were going to be incarcerated in a mental health institution, and you'd never get out. And that was a real concern by some folks who'd had some very bad experiences many, many years ago. This was educational. I can tell you my experience with the court-based mental health system, the review board, is that people rarely were locked up and had the key thrown away. The system just didn't work that way. And so what frequently happened is people would go into, my experience of the mental health system up north was people would go into it and they'd come out much, much better. And so to deal with this, we sort of educated people. I won't skip through. As you can see, we've got about 10 minutes left and I want to leave time for questions. So I'll skip through this to the other bumps in the road and get to reasons for success. Reasons for success, we got buy-in from all kind of partners on this, and the folks who were running this personally engaged with the individuals who would be partners in this and persuaded them to come. We had an overall goal of developing a mental health court, but what we did is we set mini goals along the way. So the mini goals were simple: form a committee, get agreement to support this, develop a business plan, get the local judge on board. And so each time you achieved a goal, whether it be just holding a meeting or scheduling the next meeting, and each time there was progress, it became sort of a self-fulfilling prophecy. Ultimately, the folks who were engaged in this all put time and energy into it, and that is what developed the programs that persuaded the courts we should be doing this. So where are we now? Symptoms of success. The folks who set it up ain't running it, and that's important. Not because the folks who set it up couldn't, but because if a program is set up by one individual or one group who is strongly and passionately committed to it, the program will never survive the loss of that individual. It needs to be run by organizations, not individuals, if that makes any sense. So that if a CMHA worker leaves, if a Crown leaves, like I've done, goes on to another job, the program will survive that person and move on. And so when the program started to run, the folks who were setting it up, some people remained, but many of the key people who set it up handed the next part of the job over to someone within their organization. We have Stephanie Turner, who runs this court out of the Guelph office, and she's fabulous. She's really good at this, has exactly the right set of knowledge, exactly the right attitude, and does a great job. It's been extremely successful in terms of numbers. We usually have in excess of 100 participants on this on any given day. It's using existing resources much more efficiently. One of the reasons I think the court came on board is a recognition that all of these folks going through court were going to be appearing in multiple different courts, all of whom would be eating up court time. Having them in one place where there's some specialists who can help them is simply a good thing. That's the bulk of the presentation. I'm going to stop sharing now. And I'm going to, for the last sort of 5 or 10 minutes, I'm just going to turn this over and see if we've got any questions that people would like to ask. I can see some Q&A here. I'm just going to pull up that.
You have questions in the Q&A and also in the chat. So
Okay.
I'll leave it to you to choose where you want to start.
Thanks. So I can see, Maria, I can see your question. Can Indigenous people have the option to have their matter traversed from first appearance to wellness court? If yes, are there Indigenous organizations that are able to provide culturally appropriate services? Guelph is lacking in specific Indigenous court workers. We do have Indigenous folks coming through the court, but it's very, very different from some of the other courts where there's a significant Indigenous body there. As a practical matter, when we do have Indigenous people coming through this court, absolutely they can go through the court, and there are often referrals to people like Lejew workers or other organizations. So that's identified, and the short answer is yes, we're able to provide culturally appropriate services, but it often involves looking out beyond the court. In somewhere like Kenora, our clientele will be almost entirely Indigenous, but in Guelph, it's a smaller part of the population that comes through court. So chat, let me see if I can pull the chat up. Are the there's a question from Fiona Lawrence. Are the interactions with health providers just at pre-court? Do they ever attend court? How much health information is expected or needed by the court? So this is multifaceted. So yes, the health providers like CMHA, Stonehenge, will attend the pre-court and maybe we'll be meeting with people, but there's also meetings and work that's being done outside. So at court, there may be an agreement that, okay, you're going to do X or attend this program, and that meeting may well take place elsewhere. So do they attend court? Yes. The whole point of the wellness court is to work as a hub that will allow all service providers to be there. So it's actually a requirement of the program. How much health information is expected or needed by the court? It depends. If you're going through, so if, for example, you're going through the stabilization program, it's unlikely you've signed a consent to, so if I'm accused, I'm going through the program, I'm very ill, I'm probably not signing a consent for the court or my lawyer or anyone else to have access to my health information. So the health officials are finding that out using non-consent based systems that work within the health system. I can't tell you what those systems are. I don't know. All I know is when I send someone off to a hospital, they come back usually with health history. On the other hand, a diversion worker, somebody that's being referred to diversion, may be relatively peripheral in terms of the information we've got. But usually if somebody's going through this program, for example, the wellness diversion program or the drug treatment program, they're signing consents for people to access information. Because we need health history to be able to help somebody, you can't work in a vacuum. So usually we get a fair bit of health information. As a practical matter, this will work out in favor of the accused at most times. I'm aware, for example, we may have people coming through with very, very private issues. So, for example, if someone may report a history of sexual assault or may report a history that they've got HIV. As a practical matter, the people working in court do so with a degree of sensitivity and a degree of common sense. So, for example, I've done entire sentencings where it's apparent an accused person was sexually assaulted repeatedly, when no one mentions that, but everyone knows about it because we've referred the judge to the relevant portions of the reports. But it doesn't become public in the same way that other health information may become public. So the health information varies from individual and case to case. Brittany Botello, yes, there is the meeting's being recorded and you're entitled to share it with other stakeholders. And if you missed the first few minutes, you missed the caveat that I speak on my own stead, not on behalf of the Attorney General on this. Okay. So that's the chat I see. Are there any other questions at all? I know we were aiming to finish by 2.
Doesn't look like we have any more questions. A couple of comments. Peter, just want to comment what is happening in Guelph. It demonstrates an evolution of what I call the treatment court system. Treatment courts, of course, have been around in Canada for a while, but what you've done in Guelph is that you're sort of evolving and having greater collaboration, and being able to reach people with so many different needs. So this has been a most informative presentation. Thank you for taking the time to do that. We will certainly send out the recording as soon as it is ready. But Peter, we can't thank you enough.
No, thank you very much, folks, and thank you for attending. We appreciate it.
Yeah, thank you. Okay, so with that, we'll wrap up until next time. So thank you very much.
Have a great day, everyone.